Good day. This is Dimitri Lascaris coming to you from Montreal, Canada for Reason to Resist on July 24th, 2025. For many years, Zionist lobby groups in Canada have used litigation, or threats thereof, to suppress pro-Palestinian voices and to obstruct government policies that might prove supportive of Palestinian human rights. Oftentimes, Canadian police and prosecutors respond to pressure from Zionist lobby groups by pursuing baseless criminal charges against nonviolent Palestinian solidarity activists. But increasingly, Palestinian solidarity activists are fighting back and are doing so with some success, even though they have far fewer resources than the government or Zionist lobby groups. One such activist is Canadian author and activist Yves Engler. As we covered recently on Reason to Resist, Yves was charged by Montreal police a few months ago with criminal harassment. Why? Because Yves criticized on social media a fanatical Zionist influencer by the name of Dalia Kurtz. There's been a major development in the criminal prosecution of Yves Engler, and he'll join us a little later on this program to discuss those developments. But first, we're going to speak to two Canadian lawyers who have extensive experience in litigating cases involving the Palestinian cause. And let me bring them into our discussion. So we're joined today first by Shane Martinez. Shane is a Toronto-based criminal defense and human rights lawyer. He served as counsel in the first private prosecution of Israeli military recruitment in Canada. He has pursued complaints to the Canada Revenue Agency as well regarding the funneling of charitable donations to the Israeli military. Shane also defends individuals criminalized because of their participation in Palestine solidarity protests. And he's a member of the International Center of Justice for Palestinians. Thanks for joining us today, Shane.
Thanks, Dimitri. Happy to be here.
And we are also pleased to be joined by Faisal Bhabha. He's an associate professor at Osgoode Hall Law School in Toronto, Canada. He has researched and published in areas of constitutional law, multiculturalism, law and religion, national security, and access to justice. Previously, he sat as vice chair of the Human Rights Tribunal of Ontario, and he's now a director of the Legal Center for Palestine. Good to have you here, Shane. Thanks for joining us.
Great to be here.
So, Shane, let me start with you. During Israel's genocide in Gaza, which has now been going on for nearly 2 years, it's just mind-boggling that this is still happening. Dozens of Canadians from across the country have been charged with various criminal offenses for nonviolent forms of protest, and you've defended quite a few of them. One criminal case in which you've acted as defense counsel, I understand, has come to be known as the Indigo 11. Could you please tell us about that case, the background of it, and what charges were brought against the accused?
Sure. So the Indigo 11 case was one that came about. It was one of the first Palestine related arrests in Toronto following October 7th of 2023. There was vandalism at an Indigo bookstore, the flagship store in Toronto, in relation to the Hiseg Foundation, which is operated by Heather Reisman and Jerry Schwartz. Heather Reisman is the CEO of Indigo Books. And so what ended up happening was that a number of activists took it upon themselves to engage in an act of peaceful political protest. They put up posters on the store, and red paint was applied to the store as well, representative of blood. They did this because the Hiseg Foundation that Heather Reisman and Jerry Schwartz run provides educational support to lone soldiers in Israel. So individuals from Canada who go over and volunteer in the Israeli armed forces, they have their education paid for as a result of Hiseg. It's kind of this incentive to enlist and to participate in the Israeli military. So in protest of this, this action happened at the Indigo bookstore. The fallout from that was significant. There ended up being a direct phone call between Heather Reisman and the chief of police, Myron Demkew. So we had basically a billionaire reaching out to the chief of police on more or less the same day that this incident occurred. And what happened thereafter was I would say an unprecedented police raid across the city on the homes of numerous activists, 11 in total. Saw police executing warrants at night, using battering rams to knock down doors. People were were detained. People that had nothing to do with the alleged action were detained. They were arrested. They were charged with a number of offenses: mischief, also conspiracy. They had their devices taken and searched. Some of them were observed when they were detained by the police when they were using the washroom. They were denied access to counsel for many hours on end, and a variety of other violations of their rights under the Charter. The case wound its way through the courts until it finally concluded in full this past March. Ultimately, at the end of the day, I believe it was a total of 4 people of the initial 11 who ended up entering guilty pleas. None of them received convictions. They all received conditional discharges. The remainder of the individuals had their charges withdrawn by the Crown. And so it was in large part a complete failure on the part of the
Looks like we've lost Shane. We lost you for a moment. You said it looks like a complete failure.
Yes, my apologies. So it was an entire failure on the part of the Crown to obtain any convictions whatsoever. Not a single person was convicted in relation to the offense. No one went to jail. No one walked away from it with a criminal record. And the overwhelming bulk of charges were withdrawn against those who were arrested.
So are you aware, Shane, of other instances in the past 2 years or so when criminal charges brought against Palestinian solidarity activists in Canada were dropped before trial? And if so, could you tell us briefly about that?
Sure. Yeah. I mean, many. Here in Toronto, it seems to be a fairly frequent occurrence. I've defended 8 Palestine protest-related cases since October 2023. And the charges really span the spectrum, right? From assault police, mischief, public incitement of hatred, conspiracy, you name it. In every single case, the charges were withdrawn. There were no guilty pleas. None of my clients received discharges. There were no peace bonds. It was just withdrawals. Some of the charges were simply absurd. For example, there was one where the client was charged with assaulting a police officer because the officer said that his ear was discomforted by the megaphone that the client had, and so he said that he was assaulted by the noise coming out of the megaphone. Completely frivolous charge, ended up being dropped. In other cases, we were able to rely on police misconduct to negotiate a withdrawal of the charges. Sometimes we had to call the Crown's bluff, set the matter down for trial, set dates for charter applications to be heard, and so on. And then the Crown ended up withdrawing the charges. There's currently 2 cases that I have on the go, both of which, in my opinion, are entirely meritless on the part of the Crown. Crown seeking custodial terms, jail in both of them. That's something that's become increasingly common in recent months, and we're eager to get into court to deal with those ones because I suspect that they will likely go in the direction that other cases have gone as well. We see just a very discernible pattern by the police of overcharging people, of laying charges that are meritless, and then putting conditions on people if they want to be released from the police station instead of being held for bail, getting them to agree to no protest conditions, which are unconstitutional. So to say, you won't attend any protests until your case is done, right? So they've been doing that, it seems, in a way to just kind of bully and try to apply force and pressure to individuals who are involved in this movement, and to stop them from organizing in the community. But people are pushing back. They're even when those conditions are applied, they're fighting them in court, and they're winning.
Yeah, I mean, that officer whose sensitive ear was discomfited by the loudspeaker, one wonders how he endures turning on the siren in his police cruiser. But Faisal, as I mentioned, you're on the academic side more often than the courtroom side, although you've done quite a bit of litigation. From your perspective, what do you think is going on here? This pattern that Shane describes, what does it say about the justice system? And can you talk to us also about the burdens that ordinary citizens have to endure, even if the charges against them are ultimately dropped?
Yeah, thanks. Thanks for having me, and thanks for the question. I think what Shane is describing is part of a broader picture of just rampant discrimination, and where I've seen this, and where the Legal Center for Palestine has really stepped in to meet an urgent need over the last 2 years, has been with respect to the non-criminal types of consequences that result from people's innocent participation in constitutionally protected activity like protest. And I'm not talking about civil disobedience. We can bracket the kind of like the Indigo case and separate that from, say, the protests that we've seen through the streets of Toronto, and through a combination of misinformation, of deliberate smears, of the press completely failing to do their job in presenting facts about what's happening in the city. There has been created the conditions to enable this kind of rampant discrimination that we've seen across the board, whether it's in policing or whether it's in the employment sector or the educational sector, public education. We've seen children discriminated against, and that has resulted in what you could say is quasi-criminal repercussions. So if you're a student in public education, you can face discipline, high stakes discipline, expulsions, suspensions, investigations. In higher education, we've seen the same thing. The real reliance on policies that are meant to remedy discrimination, that are meant to remedy harassment in those spaces, that are meant to be accessed by people who typically come from disadvantaged backgrounds, or who are themselves disadvantaged in some way, facing an experience of discrimination or harassment, having access to a forum and a mechanism for redress being turned on them. And so just me personally, I've assisted probably a dozen people in the post-secondary sector, whether working there or studying there, mostly students, overwhelmingly undergraduate students. So you're talking about often teenagers who have been subjected to investigations that in and of themselves are a form of punishment, because these university investigations into harassment or discrimination can last weeks, can, in the interest of protecting complainants, because like I mentioned, the whole purpose of these regimes is to protect people who are typically disadvantaged and have experienced something that aggravates their disadvantage in society. But when it's turned on them, those things that are designed to protect actually cause additional harm. So for example, complainants are shielded. I had one case where a second-year undergraduate student, so we're talking about a 19-year-old female who had come to Canada just like 5 or 6 years earlier from a war-torn country, and had embraced Canadian values, so-called Canadian values, I suppose, and was out protesting on campus, and I won't go into the details of the complaint, but essentially a complaint was brought against her for conduct that was either made up or grossly exaggerated. It was a bad faith complaint. It had been brought by anonymous complainants who were essentially anonymized because an administrator at the university put himself in the position of the complainant, perhaps himself imagining he was protecting some vulnerable young woman, when in fact what he was doing was targeting a vulnerable young woman with a process that ended up dragging her into an investigation, scaring the hell out of her, and causing her to have to engage hours of time in answering pointless questions. And she had some assistance in the form of a volunteer representative from the Legal Center of Palestine. And so that's the kind of work that the LCP has been doing. But we're talking dozens. We've got at the center records of dozens, if not hundreds, or like certainly into over 100 incidents of a similar nature from across the country, and that, we believe, is just the tip of the iceberg. And so the problem is truly immense and goes well beyond the very serious problem of the misuse of the criminal justice system by the police and by community members who who are exploiting the police to act in some ways as almost like a private security service for certain segments of the community. And so I think discrimination is rampant on all these fronts. And I've been looking at it mostly in the context of post-secondary education, public education, the workplace, and at the level of professional regulation. So we can talk more about it, but people who belong to a professional association, whether they're accountants, physiotherapists, massage therapists, or lawyers, doctors, have found themselves subjected to complaints to their professional bodies alleging that they're unfit to be members of their profession. So
yeah, as you both know, I'm sure any lawyer with experience in matters of this nature will understand readily that even if you succeed as the subject of a complaint and filed with a professional body or a university or in a criminal court, the burden of having to defend it and the prospect, just the mere risk that you're going to be sanctioned in some way, really can have a quite detrimental impact on these people, even though they may be completely innocent and usually are of any unethical behavior or sanctionable conduct. Shane, in the cases you've done, you mentioned some of these charges. What kinds of sentences in the worst cases were your clients looking at if they had actually miraculously been convicted despite the evidence? What was the potential downside to them?
So one of the interesting things is that the Crown will oftentimes not proceed by indictment with these cases. It seems as though they always proceed summarily. They may have their own reasons for it. My suspicion is that the reason why they don't proceed by indictment is because if they proceed by indictment, it means that the client gets an opportunity to go before a jury in superior court. And a jury trial is probably the last thing that the Crown wants in a political case like this. So they've always proceeded summarily. So the worst that a client would be looking at in terms of a sentence would be something in the range of 2 years less a day in jail. Still extremely serious. Even a non-custodial sentence that carries with it a criminal conviction can impact clients. Even sometimes a client not being sentenced, but even without a finding of guilt, let's say that somebody enters into a peace bond, that can sometimes impact someone's employment as well. If, for example, they're a teacher, right? So depending on the person and the nature of their circumstances, they can be impacted by any number of possible dispositions to the case. They don't necessarily have to go to jail. And there's a frequent saying in this circle, which is that the process is the punishment, right? Being charged, having your name dragged through the mud by the police publicly, having to go to court, paying a lawyer if you can't get one to represent you pro bono, going through all of that, that's in fact the punishment at the end of the day. It's not whatever the decision might be.
And even in cases where the bogus charges are ultimately dropped, the accused isn't entitled to any kind of compensation generally from the Crown, the government, for the bogus prosecution, right?
That's correct. In the criminal sphere, you wouldn't see that happen. I've had a couple clients who have pursued civil actions against the police in relation to their arrests, but that's the exception rather than the rule. Oftentimes, people don't have the time or the resources to be able to pursue that, and oftentimes they just want to get back to doing their work in the streets with their community to try and bring attention to this genocide.
Right. So Faisal, you mentioned the Legal Center for Palestine. Could you tell us about its mission, broadly speaking, what its resources are, and when and by whom it was established?
Sure. Yeah, the Legal Center for Palestine was established in 2021 by a group of activists and lawyers and community members who felt that there was a big need for services to support members of the Canadian community who are advocating for Palestine and experiencing the kinds of things that we're talking about. There was a recognition well before October 7th, 2023, that advocating for Palestine came with particular stigma, particular downside risks the Palestine exception, it is the confronting the Palestine exception is the unifying mission of the Legal Center for Palestine, and equipping those who do so to have to be able to do so with some protection. Because the thing that we haven't actually really quite observed or pointed out yet is that, you know, this isn't just, these aren't things that are just kind of happening as a result of, you know, kind of random misinformation or a constellation of unfortunate circumstances, but rather there's actually been a deliberate effort to spread misinformation and to weaponize the legal system against Palestine activism. And this originates in the United States. It's called lawfare. There's the Lawfare Project, and it's been very open for now 15 years or more. A deliberate attempt to use to essentially appropriate legal concepts like discrimination in order to condemn and smear pro-Palestine advocates as anti-Semites, in order to prevent them from doing the important human rights advocacy work that they're doing. That is analogous to any other human rights work done for any other oppressed people anywhere else in the world. And so this exception creates there's the Legal Center for Palestine is needed to serve the needs of the Palestinian community and their supporters because of this exception. And we could not have anticipated the timeliness of its founding, but certainly when October 7th happened, suddenly, and the Legal Center for Palestine had not yet had just, I think, recently really announced its existence. For the first year, it was being built up quietly in an effort to build an institution that would be capable of meeting the call. And thankfully it has been. It has grown. It has acquired greater support than ever as the broader public the need for this kind of work.
And the three of us, in the interest of full disclosure, are involved together in a major Canadian piece of litigation, along with four other counsel and the Legal Center for Palestine, the International Center of Justice for Palestine, of which Shane is a member, are spearheading that case. Could you tell us, Faisal, about that? I've talked about it a little bit on this program. Could you tell us, broadly speaking, what that case is about and what is the current status of the litigation?
Well, one of the things that the Legal Center for Palestine sought to do is to build networks and to grow the resources within the community to advocate for Palestine. So it's important that this is a collaboration between these two organizations in the interests of the community. And it really came from the community after October 7th and Israel's attack on Gaza. Very quickly, we began to hear from members of the Palestinian Canadian community asking, okay, so what's the Legal Center for Palestine going to do for Palestine? What legal action can be done? And we were hearing them, and they were members of the community quite understandably wanted to know what legal action could stop this, what was unfolding, what was becoming clearly a genocide, even as early as the 3rd, 4th week of October 2023. Stop the killing, get our family members out, bring people here. Look at what's happening in Ukraine. We were being told, look at what Canada's been able to do. Let's push for something similar. And so that was what was happening within the community. In terms of legal action, we had to really manage expectations, because we are all realists. We've all experienced our fair share of disappointment and loss in the legal system. And so when you're dealing with a community that's reeling and that's looking to the lawyers to deliver them from this evil, we had to be very careful not to overpromise. And I don't think we were perfect in our communications with the community, but there were lessons there for us. And over many months, we continued the communication with them and with each other, and we settled on an approach, which was to seek a limited remedy from the government. And that limited remedy would be to seek a recognition by the court that the government was engaging in breaches of Canadian law, the Canadian common law, which enshrines the customary principle on the need to confront genocide and prevent genocide from occurring and end genocide that is occurring. And number two, the charter rights of the claimants, and our two claimants, one of whom was in Gaza in October of 2023 and feared for his life and escaped near death, and the other was here and experienced very horribly the results of the unequal treatment that Canada has subjected Palestinian Canadians to by not allowing them to unify with their family. He directed his family to a building that he owns where he hoped and prayed that they would be safe, and they were all killed. And we can talk more about the claim, but that we're seeking a remedy, of a declaration that the government has failed in its charter and common law duties. It's been brought in superior court because it's being brought under Canadian law, not international law. And the government is seeking to strike the claim as having no chance of success.
And this, the basis of this motion to strike, which would, if it were to be successful, would prevent the plaintiffs from going into discovery and examining the relevant evidence in the government's possession. But the basis, of course, is that, well, the primary basis, I would say, is that this thing is not justiciable. The claim is not justiciable. Could you just, maybe Shane, you could just flesh out for us what the government's essential argument is? What is the basis of this motion? Looks like my question froze, Shane. So while we're waiting for Shane, perhaps you can answer.
In whole or in part. Either one.
Sorry, Shane, you froze up. Could you start your answer?
Sure.
Thank you. Thank you.
I can. And so yes, the objective that the state has here is to have the case thrown out, either in part. They either want the case to not proceed whatsoever, or they want to be able to cut out significant portions of it in an attempt to sabotage it and make it fail. The test for the court is to determine whether or not it is plain and obvious that the case has no reasonable chance of success. Obviously, our respectful position is that it most certainly has a reasonable prospect of success. And although it's novel, it is one that absolutely must be heard during this crucial time in history. When we're looking at what Canada is doing versus what its international and domestic obligations are as well, and how it has shirked all of those. When it talks about, when Canada talks about some of the issues not being justiciable, what they're essentially saying is that the court should not wade into overly political matters, so that the court should not interfere with Canada's discretion to decide how it wants to engage in foreign policy issues, the actions that it takes with respect to a genocide, and so on. They're saying that those are entirely political decisions that are within the exclusive realm of the executive, meaning the Canadian government. We're saying that part of what we're saying is that Canada is misframing this case by trying to make that argument, that this is about what Canada's legal duties are under Canadian law, given that Canadian common law has adopted these customary international norms, one of them being the duty to prevent genocide. And we're saying that this is a domestic legal obligation that the Canadian state has, and that as a result of not fulfilling that obligation, it ended up violating the charter rights of our clients under sections 7 and 15 of the charter. That it put one of our clients, that it jeopardized their right to security of the person, but it also discriminated against them as well. And that's how the two sections 7 and 15 of the charter are engaged. So we're at odds with Canada about how the case should be understood and interpreted. But ultimately in November, when the motion to strike is heard, the court will have the final to say on that. And we're ready to proceed on that.
So back to you, Faisal. You talked about the important work of the Legal Center for Palestine. We mentioned the International Center of Justice for Palestine. There are lawyers who are acting independently, who are also fighting to represent the interests of the Palestinian solidarity community, both in civil and criminal litigation across the country. But what is your assessment globally, nationally, of the balance of resources in this struggle when it comes to what one might term lawfare? Do you think now the Palestinian solidarity community is on an equal footing with the Zionist groups and the government officials who support them, or do you think we're still there's still a significant imbalance of resources?
Well, look, equal footing and imbalance of resources are not the same thing to my mind. We are not on equal footing. We have the truth and we have justice and we have reason. And those basic things, I mean, it sounds cliche, but the truth is, as more information, more correct information is being made available to the broader public, as members of the broader public seek out more correct information about what's going on, we're finding new allies all over the place, and we're finding new sources of support. And so that the growth and the momentum is in and of itself a resource. And the justness of our position, you know, look, the three of us, none of us are Palestinian, right? Like, this is so much bigger than tribal warfare, which is how some people want to kind of make it out to be. And so we have confidence in that, and we're seeing the fruits of that. In terms of, you know, financial resources, the Legal Center for Palestine, the Palestinian solidarity community broadly in Canada is grossly outmatched in relation to the Zionist lobby, the highly funded Zionist lobby that, you know, to the tune of millions and staffs of dozens, if not more, across the country, multiple institutions, organizations that networks of organizations that over the last 10 years have become two important things about that. And I'm no expert, but two things that I've observed about the pro-Israel lobby over the last 10 to 15 years is, number one, it's become much more integrated with Israel itself as a result of Israeli Hasbara. And even you can see the shift from the Canadian Jewish, the CJIS predecessor, the Center for Israel and Jewish Affairs, Canadian Center for Israel and Jewish Affairs, coming out of the Canadian Jewish previous Canadian Jewish Association with a more focus on Israel. And so, you know, this has put the cards on the table. It has intermingled the interests of Canadian Jews and Israel in a way that I think actually increases the dangers of anti-Semitism and risks of anti-Semitism, of consequences from the conduct of the State of Israel on communities, Jewish communities, and unfortunately, we've seen the outcome of that. But this has also made it more difficult to advocate, and it has intermingled a lot of the money. And so the work that's being done in the charitable front is really important to try to disentangle some of that and to call out some of these inappropriate associations.
Right. Shane, one of the very interesting matters you've worked on in the Palestinian solidarity context was a case, a private prosecution brought against, I think, one or more Canadian Israelis who had served in the military, if I'm not mistaken, or organizations that were involved in facilitating recruitment by the Israeli military of Canadian citizens. Can you tell us about that case and what happened to it ultimately?
Sure. So in Canada, we have something called the Foreign Enlistment Act, and Section 11 of the Foreign Enlistment Act makes it a criminal offense to recruit or induce someone to accept any engagement with a foreign army. Now, that doesn't appear to apply where the Israeli Defense Forces are concerned, because there are organizations in Canada which openly recruit volunteers for the Israeli military. One of them is called Sarel Canada. It recruits volunteers for what are called non-combat engagements, non-combat volunteer opportunities. The IDF refers to it as an official IDF volunteer program. Volunteers go over from Canada to Israel. They wear Israeli military uniforms. They live on the bases. They have to follow the military rules that are there. They clean tanks. They do ammunition checks. They prepare gas masks. They do everything that soldiers would do in order to free those soldiers up and go to the front lines in Gaza or elsewhere. Very clearly an engagement in the Israeli in the Israeli military. Complaints were filed a number of years ago with the Toronto police about this, saying this is happening in the city. This organization is recruiting volunteers. It's clearly illegal. There are mountains of evidence. Here it is. Please act. They refused to take any action. Then two of my clients, Rehab Nizal and David Miviser, they together brought a private prosecution. And
before you continue, I just want to clarify, Rehab Nizal is a Palestinian Canadian artist. We've actually had her on this program several times. She's in the West Bank currently. And David Miviser is a rabbi, who is an anti-Zionist rabbi who's been an outspoken critic of Israel. Is that an accurate assessment? Yeah.
Yeah, I think he would agree with that. Yeah.
Yeah. Okay. Go ahead.
And the two of them came together and they brought a private prosecution against Sarel Canada. And so to do this, the criminal code says that you have to go before a justice of the peace who's similar to a judge. You have to present sufficient evidence to the court on all of the elements of the offense. And only if you can present sufficient evidence on all of the elements of the offense will a charge be laid against that entity. And then you will be allowed to privately prosecute that case, the same way that the Crown would prosecute a case. We succeeded in doing that. We presented evidence on all of the elements of the offenses, of the offense. Sarel Canada was formally charged. They had to attend court. They ended up having to hire counsel. And what ended up happening, though, is that the Crown, the Public Prosecution Service of Canada, exercised their discretion to intervene in the case. They took it over and then they shut it down so that it never ended up reaching trial. Their rationale was that there was no evidence of an engagement with the Israeli military, right? So that it just flew in the face of reality. You can imagine if Russia, North Korea, Iran, any country that Canada takes issue with was doing the exact same thing. Imagine that they were recruiting volunteers here to go over and do the same tasks that these individuals were doing. It would never stand. That organization would be charged. It would be shut down immediately. But because it's Israel, there's this exception that applies informally by the Canadian state in terms of how it treats it. And it's this exception that Canada applies to the Israeli military in many different realms. So what they did was they intervened, they shut the case down, and it never ended up making it to trial. We ended up appealing it, that decision, and it was a bit of a mixed win. It was what we would call a procedural victory, but a substantive loss. So we said that the Canadian government acted in bad faith and with improper motives when they took over the case and they shut it down. The court did not agree with us on that. They said that we weren't able to prove that there was bias on the part of the Canadian government when they were engaging in this, and that we weren't able to prove that they interfered for an improper purpose. However, what we did win as a procedural win was that we were able to prove that private prosecutors are allowed to challenge the Canadian state in appeal when they do try to take over cases and shut them down. So Canada was actually saying that the appeal shouldn't have been heard at all because we shouldn't have standing to be able to bring the certiorari application to challenge what Canada had done. So we were able to get a decision from the Court of Appeal, which was a win in that sense and allows us to continue fighting them in the future. But yeah, that was that private prosecution, and we anticipate that there's going to be more private prosecutions coming down the pipe in the near future in other cases.
So I'd like to conclude by putting both of you on the hot seat and ask you a delicate question about the legal profession in Canada. This is something that I've been ranting about for months, and so I'm going to, sort of highlight the import of my question by focusing on one particular member of the legal profession, a character by the name of Howard Levitt. Howard Levitt is reputed to be one of the best employment lawyers in Canada. He also has a column for the flagship newspaper of Post Media. It's called the National Post. I believe is a weekly column. He has been, I think it's fair to say, viciously attacking Palestinian solidarity activists, particularly in the university context. And, I just highlight Howard, but my question is more broadly about the prominent members of the legal profession. Bay Street, which is our equivalent of Wall Street, there are thousands and thousands of very well-compensated lawyers serving the corporate community on Bay Street. I'm not aware of a single one who has spoken out, a prominent, well-heeled lawyer from Bay Street who has spoken out in defense of the Palestinian cause. But there are quite a few people like Howard Levitt, who from their positions of affluence and power within the legal profession have been bitterly condemning those who oppose this genocide. What is your overall assessment of the response of Canada's legal profession to this genocide? Obviously, there are people across the country, we're just three of them, but there are numerous others from diverse backgrounds who are fighting for the Palestinian cause, oftentimes for no compensation. But overall, what is your assessment of the Canadian legal profession's response? Why don't I start with you, Faisal?
Sure. I mean, Howard Levitt wrote a couple of articles targeting me specifically. Just that's not a badge. Well, maybe it's a badge of honor, but I'm just putting it out there. Maybe I'm biased, but first of all, he's not a great employment lawyer, and second of all, I don't think he speaks for Canadian Jews. But I do think that he represents an attitude that bullies everybody, including members of the Canadian Jewish community. And so, I've been mostly disgusted by the legal profession broadly for the reasons that you allude to in your question, the silence in the halls of power, and then when incidents like an organization like the Advocate Society canceling the invitation of an Arab chocolatier who has posted some mildly pro-Palestine social media posts, and then when you look behind the scenes, you see some of the more private communications and the nature of those communications of these power holders in the profession, and the disgust level kind of rises, but nothing too surprising. But the thing that I want to say that has brought me a lot of hope is that or let's say a small measure of hope, because it could be better, is a lot of those quiet members of the legal profession, and I'll say members of the Canadian Jewish community who are not speaking out with Howard Levitt and are not speaking out against Howard Levitt or the likes of, but who are who are similarly disgusted, like I am, and like you are, and like others are. But I think there are particular reasons within the Jewish community, within people who belong to that community, as to when and how one feels it's appropriate to dissent. And I think that community, like my community, for example, after 9/11, had a lot of work to do in terms of where we stood with respect to human rights and foreign policy. And I can say I'm actually quite proud of the record of the Canadian Muslim community in relation to how it, a much newer community, a much less Canadianized community at that time in 2001, nonetheless dealt with the pressures of the expectations of our citizenship and commitments to values of our citizenship, concerns and alliances around foreign policy. I think the Canadian Jewish community, notwithstanding, or perhaps because of its resources and its privileges, has completely failed. And that's not to say that there aren't Canadian Jews who have impressed me beyond belief, and there are. And there are allies to the Palestinian cause amongst Canadian Jews that have been there all along, and there are new allies that have been stepping up, and there are organizations that are growing, and I think the trajectory is moving in a great way. But I think the institutional Canadian Jewish community has been a complete disappointment over the last 2 years, and it has a lot of stock taking to engage in, and that's not really for me to prescribe, but I just think that needs to happen. And I'm speaking from a place of empathy as a member of a community that went through something very similar after 9/11. As a lawyer, I think we need to see better from our fellow lawyers, and I think that the legal community is very divided right now because of this. Those of us that have been advocating for Palestine know who our allies are, and we know who our adversaries are, and I just don't see any cohesion on this front anytime soon.
And Shane, what's your overall assessment? Do you have is your view similar to Faisal's, and do you share my disappointment? And I think it's fair to say Faisal's disappointment in the more, shall we say, prominent members of the legal profession in Canada.
I do share Faisal's sentiments, and I share your disappointment as well, Dimitri. When I hear your rants, I think you referred to them as that in your videos. I can't help but agree each time. There's this overwhelming state of complacency among the Canadian legal profession with what is happening, particularly among so-called human rights lawyers. I honestly don't know how anyone that calls themselves a human rights lawyer is going to be able to do that going forward if they haven't spoken out against the genocide that's happening right now. Absolutely shameful, and there's no excuse for remaining silent. I mean, some listservs, you can't, among lawyers in Toronto, you can't even mention the word Palestine without being inundated with attacks about, do you condemn Hamas and this and that. Even if you were to mention something that's relevant to the profession and the topic of that listserv, in the context of Palestine, that's just how hostile it can be. And, for some people, particularly for more junior lawyers, there's this real fear of losing their jobs, right out the gate, or not getting jobs at all. And, that is of concern to them. And I do adjunct teaching at the same law school where Faisal's at. And I've had students come up to me and express those concerns. But I've also had, through the International Center of Justice for Palestinians, I've had many students and lawyers as well reach out to us and connect with us and do very valuable work behind the scenes. So, although there is that silence, at times maybe we don't want to read too much into it because people are doing work a bit more quietly. Ideally, people would speak out, but the reality of the profession right now is that it is so hostile and it is so confrontational to anyone who speaks for Palestinian human rights that people are trying to find a way to do the work without sacrificing their ability to feed their family and get by and start their careers. So all in all, it is really a bad situation all around. But we do need to continue speaking about it, calling it out, and especially confronting those lawyers who are apologists for Israel and what is happening right now, because that is particularly reprehensible and needs to be called out the same way that we would expect to call out anyone else who is an apologist or a defender of a state committing genocide in any other context.
Yeah, I can't. I've lost count of the number of young lawyers, articling students and law students who come to me privately and said that they desperately want to speak out, but they're mortally afraid of doing so, how it's going to impact their careers. Probably the stage people I've never heard from before suddenly coming forward and asking, how do you do it? How do you, as a member of the bar, survive professionally while being outspoken about Israel's crimes? And, it's terrible that they have to ask that question. It's just unbelievable. In any event, I'd like to conclude by offering to Faisal an opportunity to tell people how they can support the Legal Center for Palestine if they're inclined to do that. And I'll share the information also in the description of this video. But why don't you take a minute to point people in the right direction?
Thank you. Yeah, please check out our website. I think it's lcpal.ca. Where we've got Instagram page that's quite active. You can find information. There's educational material, and there's a donation page as well. There's also a reporting tool, and it's very important that anybody who's experienced anti-Palestinian racism or any sort of backlash consequence in your workplace, in your educational institution, or anywhere else, that you report it to us. We're trying to keep track of those numbers. Thank you.
Okay, thank you very much. We're going to be joined in a couple of minutes by Yves Engler, and we'll get an update from him about an important development in his criminal case. In the interim, I want to thank you both gentlemen very much for taking the time to speak with me today.
Pleasure.
Thanks.
Thanks. We'll talk soon. So Yves, author and activist Yves Engler is here again today to speak to us about the criminal prosecution launched against him in Montreal. and also about his campaign to be the NDP leader. Thank you very much, Yves, for joining me again today.
Thanks for having me.
So, Yves, before I ask you to update us on developments in your criminal case, could you just summarize briefly for the audience what the case is all about?
Back in February, I was charged with 2 charges for supposedly harassing Zionist influencer Dalia Kurtz, and which was just posting responses to her racist, violent posts on X. And when I wrote about this and called on people to email the police to drop the charges, the police then added 4 more charges saying essentially I was harassing the police and disrupting police activities. And I ended up spending 5 days in jail to defeat successfully this condition that said I could not talk about the case or specifically talk about Dalia Kurtz. We defeated that condition, but it took 5 days in jail. And so this just on last week, we had a court hearing to decide the actual trial. And at that hearing or that day, the prosecution finally dropped the Dalia Kurtz charges, the 2 charges claiming I was harassing this really racist, violent Zionist influencer.
And when the Crown dropped these charges, did it give any kind of an explanation to the court or to the press about why it was dropping charges?
No, they just sent that to my lawyer in a private communication saying they were dropping it. So I can speculate. I would speculate that they didn't want Dalia Kurtz to testify because Dalia Kurtz is pretty extreme in her support for killing children in Gaza, and she's also comes across as I would say a little bit unhinged, and I was a little bit disappointed because part of me did want her to be interrogated, and but no, they didn't give any explanation for why.
Now, as you may recall, Yves, when I first interviewed you about this, I said something along the lines of, I would wager my house that they're going to drop the charges. I'm sure you recall that. And it's not because I have a brilliant legal mind. It's because a first-year law student could have figured out that this was total BS and there was no basis to the criminal prosecution. It just was so obvious. And I maintain the same thing about these other charges against you relating to the so-called criminal harassment of the cops. I'm predicting, I'm going on a limb now, and I'm saying those damn things are going to be dropped as well. But the thing that's so bizarre here, Yves, okay, that just blows my mind, is the charges that remain outstanding against you, right? This alleged criminal harassment of the cops. The reason why those charges were brought was because you were calling on people to contact the police and urge them to drop the charges, which they've now dropped. In other words, it does appear that your request for assistance from sympathetic members of the public was entirely justified, that these were baseless charges because they've been dropped. And yet they're keeping the criminal harassment against the cops charges outstanding against you. Again, have you been given any kind of an explanation by the Crown, or has it one been offered to the press about why they're pursuing those charges and they've dropped the ones against in relating to Dalia Kurtz?
No. And there is actually a one-day trial set for November 28th. So they are acting like they're going forward with this. So they've already wasted quite a bit of judicial resources on this endeavor. Yeah, I mean, no, they're not giving an explanation. I presume what they're going to do is basically wait till the last minute and then drop the charges just before. And so we waste all our time to prepare a defense. And a day or two before or something like that, they'll say, we're not going to pursue this. The political implications of this are not insignificant. Also, I hadn't really focused on that because I was kind of focused more on the Dalia Kurtz side. But the police are essentially saying that communicating with the police to pass a political demand, or in this case, dropping charges. They're saying that's entrave was the French word, or interference in police affairs, and is harassment of the investigator. And I've been involved in dozens and dozens of email campaigns and all kinds of different public figures, obviously politicians, also even the police. We've had campaigns around the Foreign Enlistment Act and inducing Canadians to join the Israeli military. So we've even had that with the police. In this case, it was an investigator. It's, I guess, a little bit further down the chain of command. It's not, the RCMP commissioner. But it's not like a private email. It was the police's email that for their work. So weren't like I don't know, harassing them at home or phoning their home phone number or private email or anything like that. And the letter is nothing offensive in the letter whatsoever. And then you enter this question is like, so what about everyone who emailed? It's like 4,300 people that emailed. Were they all engaged in criminal activity, right? Why is it just me? I didn't force anyone to email. I just said, there's this action alert. If you think these charges should be dropped, send an email. I'm not even sure if I can't remember even if I sent an email myself. I don't remember one way or another. So the implications here are a bit broader in terms of this sort of the police deciding that email campaigns are harassment or interference in their affairs, when that's, I think, democracy. And obviously on top of that, the fact that the charges themselves were abandoned, further adds to that this was a totally legitimate demand. It was not at all. It's ultimately the position of the Crown. But yeah, so I plan to not just mount a legal defense, but also to a political campaign, and actually maybe another email campaign to the prosecution saying you should drop this. This is ridiculous. This is you're just wasting everyone's time and resources. Already, I've spent 5 days in jail on a condition that you ultimately abandon the charge, and I've already spent 5 days in jail defeating that condition. Yeah, there's a broader political implications as well.
Yeah, I mean, the fact they dropped the charges is as much proof as you could possibly want that what these 4,300 people were asking the cops to do, to drop bogus charges, was entirely correct. They were entirely justified. And I would have thought, Yves, I'm sure you're a very capable lawyer, has turned his mind to this, that this is really a frontal assault on the free speech rights, not only of you, but of all the people who supported you by sending an email to the cops and asking them to do what they ultimately felt obliged to do, which is to drop these charges. So this is just an extraordinary abuse of police power, it seems to me. And it goes well beyond, as you say, your own particular rights, but impacts the right to free speech, Palestinian solidarity activism of the general public. Now, I'd like to move on, and before we close it out, just to give people an update of your NDP campaign. While all of this has been going on, and as we also reported on Reason to Resist, you have thrown your hat into the ring for the NDP leadership contest. And I think there's been some news about the requirements for entering this contest that has come out since we last spoke. But could you tell us basically where your campaign stands and, broadly speaking, what lies ahead in terms of this leadership contest?
Yeah, they announced some rules. We don't have the full rules of the race, but basically, one piece is that you have to raise 100,000. You have to give 100,000 to the NDP to participate in the race, which is a significant amount, much more than the 2017. It was 30,000, and in the previous one was 15,000. And in both those cases, they actually had many more MPs in Parliament than they do today. They're down to 7. So it's a little bit an inversion there. The big financial outlay, and I should say also they're going to take 25% of any other money that a campaign raises. So if you were to raise 100, you'd pay them, and then you say you raise another 100,000 to actually do your campaign. The party takes 25,000 of that. That's designed. All this is designed to basically narrow the parameters of debate and try to keep out, sort of insurgency campaigns or more left-wing campaigns, working class campaigns and whatnot. But and they also announced they'll start sometime in September. Officially, the race starts in September and it goes until the NDP convention in the end of March. So it's quite a long period. So right now we're in a pre-campaign. There's going to be some vetting process. That's going to be a big hurdle to climb. We're assuming there's already aggressive push from Zionist organizations to have me excluded from the race. They began with a whole anti-Semitism angle. Now they seem to have moved on to I'm a Rwanda genocide denier. B'nai B'rith came out with a statement yesterday or day before yesterday on this, and I've been got a communication from the Toronto Sun right-wing columnist there saying he's going to write about it, wanting my comment on the matter. So they picked up on an article I wrote in 2017, and suddenly it got article hadn't been read in a couple dozen people over the last 8 years. Suddenly it was on my site, was read by multiple thousands of people, and there was a whole push on that front. And I would presume there's going to be all kinds more direction of the smears coming. We've been able to get a certain amount of positive attention in some Hill Times and Sarnia paper, a few publications, a whole bunch of criticism in the Canadian Jewish News and elsewhere. And our volunteer network's building. We're over 200 volunteers have signed up. We got some handful of half dozen groups, communications, fundraising committees getting going, and so we have we're moving, and it's I would say it's coming together decently. We're not obviously not the front runner here, but we do I think we do have a shot. It may be a long shot, but I think there's a lot of people who are obviously appalled by Canada's support for the live stream Holocaust in Gaza. But there's also a lot of people who are like, here we have a situation where, 4.7 million barrels of tar sands is planned to be extracted in the next, going to get up to, I think it's 2034. No one is saying shut down the tar sands. No one's even using the word tar sands anymore. I'm calling for, shutting down the tar sands immediately. Is that 2 years? Is that 5 years? We can debate about some of those, but immediately phase out the tar sands. I'm talking about obviously not increasing military spending, but reducing military spending and putting that money into social programs and social entitlements. We're in a situation where there's going to be big cutbacks to social programs, all to put that money into the war machine. And what we've seen in Gaza is that these people, the notion of giving these monsters who've been enabling this live stream Holocaust, giving them greater resources to wage violence internationally. I mean, that is certainly not something that we want to do. But that's the direction things are going. Most of the NDP leadership is not willing to push back on that. I'm pushing back on that. We're, putting forward proposal for economic democracy, abolishing billionaires, having true democracy, not just in the political arena. And so, so the campaigns, it's moving forward, but we'll see, what transpires with when the formal process begins in September. I think we're going to have the best ground game by the time the race officially launches. Whether the NDP brass see that as too much of a threat and try to block us, we'll see.
And if people join the party now, the New Democratic Party, to support you, would they be eligible to vote in the leadership contest?
They'll be eligible to vote so long as people become members before, I think it's 60 days before the vote. So essentially sometime in mid to late January.
Okay. And you mentioned people can sign up to volunteer for your campaign. Is it possible for you to accept donations at this time, or is that not yet set up?
Well, we sort of informally. We don't have the formal structure, and there's all kinds of legal questions. And we have a finance committee that's setting up all that infrastructure. Of course, we already have costs, and so we do need donations. But at the moment, there have been some donations to the Socialist Caucus. There's been some donations to me personally, but we are in the process of setting up the formalized fundraising kind of tools.
Right. And I imagine you'll be posting that information where they can make the donations on your X account, which is at Engler Eve. Is that right?
Yeah, and that's why we're looking to get people's emails and stuff when things get further ironed out. We're going to be, asking people very formally for donations and asking people very formally to do this, take this action and stuff like that.
Okay. Well, thank you very much for joining us today, Yves. We'll definitely keep people posted about these bogus charges that remain outstanding against you. But congratulations on the first round of victory in this legal battle.
Thanks.
And this is Dimitri Lascaris and Yves Engler coming to you from Montreal on July 24th, 2025.